A big gut punch to the Trump administration as an individual by the name of Kathy Harris has been ordered by a court to return to the job that she was fired from by the Trump administration, Doge, whatever they're doing, kind of targeting these kind of key people in these key positions. So Kathy Harris was one of the board members of the Merit Systems Protection Board. And obviously, Donald Trump doesn't want people to have merit systems protections. So the people who are protecting people in the federal government from these firings, Kathy Harris, was fired the same way Trump fired the head of the Office of Special Counsel, who investigates unlawful firings within the executive branch as well. But here, this federal judge says not only was the firing of Kathy Harris unlawful and improper, the judge says the remedy here is that she should go back to work. Now, we've never really had, he ordered her to be rehired by an executive branch that wants her gone. Now, it's for people who are saying, well, that makes sense. Well, look, some of the remedies for this would normally be financial remedies, damages. It's not like someone like Kathy Harris would be without a remedy. But because this is such a unique situation with the Trump corruption, we're kind of in new territory here. I mean, there's some precedent, I guess, to deal with this, Harry, but we're in unusual circumstances where it feels like more than just monetary relief is needed. I mean, so what happens? Trump could just break all of the laws and the only remedy is money, but the person's life and dignity is stripped away and their position stripped away. And then they have to wait 2 or 3 years maybe to get a verdict. And then there's an appeal. So that's a problem. So Harry, what are you seeing here? Tell us about this order. How big of a deal is it? This is going to go to the Supreme Court, just like that special counsel case, huh?
I think it is, Ben, and in the same kind of issue. So district court did what a district court should do, applied the current law. And without getting too nerdy on your listeners, there's a really important case from 1935 where the Supreme Court, I'll give the name because we're going to be hearing about it, Humphrey's Executor, where the Supreme Court said, you know what, it's okay if you have multiple heads of a agency like Griffin was for the Merit Systems Protection Board, like the NLRB, then you don't have to permit the president to remove them for any reason at all. But there are cases that have happened since that case where they distinguished the case but didn't overrule it. And what it's going to come down to is the amount of power exercised by the board and what sort of power it is. So on the one hand, a pretty decisive victory, especially the remedy piece, which I'll come right back to. On the other hand, from the start, this has been something that's going to be going up. The Supreme Court's already drawn one line in the Consumer Protection Finance Bureau case. And the question is, on what side of the line will this case fall? Same for Hampton Dinger, an individual, but one who doesn't exercise prosecutorial power so much. That's going to be the fight that we are going to have. Now, on remedy, I mean, you're right. Either way, it's just funky, right? She goes back to the place that doesn't want her and sits in that chair, and how does it work? But, and moreover, you can see the sort of independent argument, and they made it, the Trump administration. Even if you tell us we broke the law here, you can't force a particular person down the president's throat. But that's what it means to not have had the power to remove in the first instance. And so half of this, it's like a 35-page opinion, pretty scholarly opinion by Judge Contreras, is about the remedy. And you'll see the administration challenge both aspects of it. And you'll see that happen if there's not a decisive decision in the Court of Appeals. You're going to see that in the Supreme Court. So I like the tone of this. It's another, the administration's been taking it on the chin again and again. But we got to remember these kinds of cases and where the Supreme Court line should be drawn that's going to figure to be decided higher up and in 6 months, a year, whatever. But as of today, the order was issued. She's back in her job, in her chair, in her desk.
This is also somewhat related to the Hampton Dinger case as well, in terms of what the remedy is there. Do you think that I'll let you remind people what the Hampton Dinger case is all about, but my question for you is, after you give a little background, do you think that there's even the Supreme Court combines the Dinger and the Harris case and kind of hears them both at the same time, through some expedited briefing process? And, when you and I last talked and went on, I mean, things are moving so quickly.
Yeah.
The Dinger, the Supreme Court ultimately allowed the district court the time to rule on the permanent injunction, or the more fulsome restraining order, rather, which it ultimately did grant.
Yeah.
And in that interim period, Dinger was smart. So behind the scenes, Dinger just wanted to buy enough time, it seemed, to be able to put out his advisory ruling that these probationary terminations were all unlawful. And he made it with respect to 6 individuals, but almost like a class action, said it would apply to all similarly situated probationary employees. They would be deemed unlawfully terminated as well. So what does this all mean, for those probationary employees?
So legally, you're right. Yeah, legally it's the same. Legally, it's Dinger. You have to have cause under the statute. Remember, this is about Congress. All these things are, the administration, the executive branch, just thumbing its nose at Congress. Congress said, you want to remove this guy? You need a good reason. You want to remove anybody on the board, in the Merit System Protection Board, you need a good reason. They didn't have a good reason. They know they didn't have a good reason. They removed him anyway. And just as with her, not only did Dinger win, but as you say, he went back to the job and started really issuing advisory type opinions. One of the arguments is he doesn't have the final say, but it gets a lot of weight about the different things they've been doing with probationary employees. But yeah, I see a similar thing happening now. That the administration basically pulled its emergency sky is falling trick. It didn't work with Dinger because of the nature of the actual order, but you could see it again here. They could say, you don't have to decide now, but you could. The whole, can you keep the president from just exercising removal for any reason at all? That's an issue. But they could also say, emergency court, keep us. We're getting an irreparable injury if you force this terrible holdover down our throats. And on that basis, do it very quickly. Now, very similar issue. Will they package them together? Best guess is no, because the facts are somewhat dissimilar and everyone knows one will control the other, but you could see it. That's a vote of 4 or 5 and how they want to go. If they do it together, it's a very strong signal that they're probably going to reverse, and in both cases. But it's of a piece, and it's all the same kind of crap on their part. And I shouldn't say, I should say crap, even though the Supreme Court may well, or the Roberts Court may well uphold it. But it's the same thing of, we don't care if Congress, which had good reason, right? You want impartial people. You want political insulation when you're deciding whether people have been, really treated badly by the executive branch. But that's going to be the, very question. Will the Supreme Court say, even though you're disobeying what Congress says, you have a right under the Constitution? And the more conservative members of the court, starting with 2 or 3 that we could name very easily, will start with sympathy for that position.
But Harry, just so people are like, well, that would be unfair if these people don't go back to their jobs, if they were fired unfairly. By the way, I'm very sympathetic to that. I agree with that. But these people have damages lawsuits, right? I mean,
they're
going to sue the crap out of the government for doing this. and for lying about the grounds of termination, saying that it's for cause when it wasn't for cause. They're going to haul into depositions people who from the Trump administration who are going to have to go under oath, and they're not going to be able to justify what the hell is even happening. And, and juries are going to hear this. And so now, 2 years from now, when these cases get heard, you could be hearing about one after another $10 million verdict, $50 million verdict, $30 million verdict, monster wrongful termination verdicts, the likes of which Harry, I did wrongful term cases when I was a litigator. There was never evidence this smoking gun. Are you kidding me?
They totally, but it's not just the top dogs, Ben. It's going to be the whole cadre of people that they're just trying to hollow out. I mean, look at, I don't know, Andy McCabe. Yeah, at the end of the day, a big check. Trump doesn't care, but among other when you're tabulating the damages of all he's done, the taxpayers are going to take it on the nose and have to pay this again and again and again. And for him, that's the cost of doing business, especially when somebody else is paying it.
There it is. Harry Litman from the Talking Feds YouTube, Talking Feds Substack, Talking Feds podcast. It's where I get my legal news from. So I hope it's where you'll get your legal news from as well. Harry tells it like it is. Thanks, Harry.
Thank you, Ben. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.